Imagine this. You move into your dream condo in California. The walls are freshly painted, the hardwood floors shine, and the sales agent tells you this is a quiet, well-managed community. You settle in, unpack your boxes, and look forward to finally enjoying peace in your new home. But then it begins. Through the vents, through the walls, even through the smallest cracks, cigarette smoke drifts into your living room. It settles into your furniture. It clings to your clothes. It burns your throat. By the next morning, your entire unit smells like an ashtray. And this isn't just once. It happens every single day. You complain to the homeowners association. You write emails. You attend board meetings. You ask the property manager to do something. Anything. The answer comes back the same every time. Sorry, there's nothing we can do. Smoking isn't banned in our rules. For most people, that would be frustrating enough. But for one California homeowner, the stakes were higher. This wasn't about smell or inconvenience. The smoke triggered medical problems, asthma attacks, shortness of breath, sleepless nights, even trips to urgent care. And when the HOA still refused to act, the homeowner drew a line in the sand. If you don't protect me in my own home, they warned, I will sue. And I won't just sue the smoker. I'll sue the association too. Pause on that. Because what seems like a neighbor-to-neighbor dispute is actually a legal nightmare. In California, HOAs don't just decide paint colors or pool hours. They have a legal duty to enforce the covenants, conditions, and restrictions, better known as CC&Rs, that every buyer agrees to when they purchase property. Hidden inside nearly every set of CC&Rs is a section called the Nuisance Clause. The Nuisance Clause says something simple. No homeowner can use their property in a way that interferes with the quiet enjoyment of others. And California courts have already decided that secondhand smoke can count as a nuisance. If an HOA ignores it, the board can be held just as responsible as the smoker. So picture yourself as a board member. Do you risk being dragged into court? Do you ignore the complaint and hope it goes away? Or do you step in and try to stop the smoke, knowing you're about to make at least one neighbor furious? This is the impossible choice facing HOAs across the country. On one side are smokers who argue, it's my private unit. I should be able to do what I want inside my own home. On the other side are neighbors who say, your smoke doesn't stay in your unit, it comes into mine. It's making me sick. And now my children can't even sleep without coughing. And right in the middle sits the association. Volunteer board members who never imagined they'd be asked to referee a fight that could cost the community thousands of dollars. If you think this is just a scare story, it's not. In 2013, a California jury ruled against an HOA in the case of Chauncey versus Bella Palermo. The HOA ignored complaints about drifting smoke. The complaining family had children with asthma. The jury sided with the family and ordered the HOA to pay damages and attorney fees. That case became a warning shot to every HOA in the state. Doing nothing is the riskiest choice of all. Back to our homeowner. They weren't asking for an overnight ban on smoking across the community. They weren't demanding that everyone's personal freedoms be stripped away. They were asking for something much simpler: protection in their own home. A guarantee that their neighbor's smoke wouldn't invade their living space every single day. But the management company insisted their hands were tied. Their advice to the board was blunt. Unless smoking is specifically banned in the CC&Rs, all you can do is send letters. You can't force the neighbor to stop. On paper, that sounded cautious. In reality, it left the board exposed. Every complaint that went unanswered, every letter that went nowhere, added to a trail of evidence showing negligence. That's when the homeowner dropped the ultimatum. If you won't help me, then I'll take this to court. And I'll let a jury decide whether secondhand smoke is a nuisance. Think about what that means. A single cigarette could cost an HOA thousands. A single puff drifting through a wall could become a lawsuit that drains the association's reserves and raises everyone's dues. And this isn't just about smoking. This is about a deeper tension baked into every HOA. The clash between private rights and collective responsibility. Where does your right to do what you want in your own home end? And where does your neighbor's right to breathe clean air begin? That is the question this case forces every homeowner and every board member to confront. Today we're going to follow this story all the way through. We'll look at how the conflict began, what the HOA did and didn't do, the wider pattern of similar disputes across the country, and the legal risks that every HOA needs to understand. Because this isn't just about smoke. This is about accountability, health, and the hidden liabilities buried inside your CC&Rs. So let's dig into the full story of one HOA, one smoker, one suffering neighbor, and one looming lawsuit that could change the rules for everyone. The story begins in a quiet California condominium community, the kind of place marketed as safe, orderly, and neighbor-friendly. Like many HOA-managed neighborhoods, this one promised consistency, tidy common areas, and a board of directors to keep things running smoothly. For new buyers, it was the image of security. The homeowner at the center of this case was no different. They purchased their unit expecting peace. They weren't looking for conflict. They weren't trying to stir trouble. They simply wanted a comfortable home where they could breathe easy, rest at night, and live without worrying about what was happening in the unit next door. But soon after moving in, the first problem appeared. Smoke. Not just the faint trace of a neighbor lighting up outside, but heavy, unmistakable cigarette smoke drifting in through vents and walls. It wasn't just an annoyance. It was invasive, constant, and impossible to ignore. The smell spread through the living room, the bedroom, and into every corner of the home. At first, the homeowner tried small solutions. Air purifiers, fans, even weather stripping around doors. None of it made a difference. The smoke kept coming, night after night, day after day. What made this worse was that the homeowner wasn't just bothered by the odor. They had underlying health conditions that turned every puff of secondhand smoke into a hazard. Asthma flare-ups, irritated sinuses, headaches, and sleepless nights became the norm. The situation quickly shifted from frustration to something far more serious: health and safety. So the homeowner did what the governing documents told them to do. They filed complaints with the HOA. They put their concerns in writing. They reported the problem formally, expecting that the association would step in to resolve it. After all, that is why HOAs exist, to enforce community standards and handle disputes that individual neighbors can solve on their own. The first response came from the property management company. Their message was straightforward. The association had no smoking ban in its rules. Without a specific prohibition in the CC&Rs, they argued, the board couldn't force the neighbor to stop. The most they could do was send a letter asking the smoker to be considerate. That answer set the stage for everything that followed. From the homeowner's perspective, the management company's response wasn't just unhelpful. It was unacceptable. They were suffering real harm inside their own unit. They pointed to the nuisance clause in the governing documents, which prohibits any homeowner from interfering with another's right to quiet enjoyment. How could the HOA ignore that? From the management company's side, the issue was less about compassion and more about liability. Their advice to the board was cautious. Do not act beyond what the CC&Rs explicitly allow. In their eyes, enforcement without a smoking ban could expose the HOA to a different kind of lawsuit, one from the smoker. And so the conflict deepened. The homeowner kept filing complaints, each one more urgent than the last. The smoke wasn't letting up. It was harming their health, disrupting their life, and now they were keeping medical documentation to prove it. Meanwhile, the HOA board found itself trapped between two risks. If they enforced the nuisance clause too aggressively, the smoker might claim harassment or overreach. If they failed to act, the complaining homeowner might sue for negligence. To make matters worse, the board members were volunteers, ordinary neighbors. None of them had signed up to referee a battle over secondhand smoke, much less one that carried the weight of potential litigation. Yet, that was exactly the position they found themselves in. This is where the California legal landscape adds another layer of tension. Across the state, cases have already established that smoke can be considered a nuisance. Courts have shown they are willing to hold HOAs accountable for ignoring health-based complaints. One case in particular, Chauncey v. Bella Palermo, loomed large over this dispute. In that trial, a jury found an HOA liable after it failed to address a family AS complaints about drifting smoke. Damages and attorney fees were awarded. The message was clear. Associations cannot hide behind technicalities when health and safety are at risk. The homeowner knew this precedent. They cited it. They reminded the board that ignoring them wasn't just unfair, it was dangerous. Their message grew sharper with each unanswered complaint. If you don't do something, they warned, then I will take this to court. I will hold the HOA responsible, not just my neighbor. For the association, this was a nightmare scenario. A single homeowner's medical documentation, combined with repeated complaints, could be enough to sway a jury. The financial consequences could devastate the community. Legal fees alone could drain reserves and force the board to raise dues or impose special assessments on every owner. And yet, despite all of this, the management company kept insisting that enforcement was impossible without a smoking ban. Letters were sent, but the smoking continued. The board hesitated, afraid to make the wrong move. The homeowner grew more desperate, convinced the HOA was leaving them to suffer without protection. This is the point where the conflict stopped being about one neighbor's cigarettes. It became about the role of the HOA itself. What is the true duty of an association? Is it simply to enforce the letter of the CC&Rs? Or is it to protect the health and safety of residents, even if that means interpreting the nuisance clause more broadly? For the homeowner, the answer was obvious. The HOA's duty was to act. For the board, the answer was murkier. And in that gap between expectation and hesitation, the seeds of litigation were planted. The case introduction leaves us here, with a homeowner ready to sue, a board caught between legal risks, and a management company warning against overreach. The next stage of the story would determine not only the fate of this community, but also serve as a lesson for HOAs everywhere. Because when secondhand smoke drifts through walls and vents, the question isn't just about personal freedoms. It is about who pays the price when one neighbor's choices invade another neighbor's home. And that is where the real conflict begins. But what started as a nuisance complaint was about to spiral into something far bigger, a clash of letters, warnings, legal threats, and the looming shadow of a lawsuit that would test the limits of what an HOA could ignore. The first signs of escalation came with the homeowner's persistence. This wasn't a single email or a one-time phone call. It became a paper trail, organized, documented, and impossible to dismiss. Each new letter to the board outlined dates, times, and the intensity of the smoke. The homeowner even attached photos of air quality monitors showing spikes whenever the neighbor lit up. They weren't just complaining anymore. They were building a case. Meanwhile, the neighbor who smoked seemed entirely unfazed. According to comments in the original Reddit thread, they weren't rude or confrontational, but they weren't willing to change either. Their stance was simple. There's no rule against it, and they're smoking inside their own property. From their perspective, the HOA had no authority to tell them otherwise. The board's response was a series of courtesy letters that read more like suggestions than enforcement. Polite notes urging the smoker to be considerate, gentle reminders that neighbors should respect one another, nothing binding, nothing with teeth, and as expected, the smoke continued to roll through the vents like clockwork. For the homeowner, this felt like betrayal. They had paid dues faithfully. They had followed every rule, painted their home the approved color, and maintained their unit just as the CC&Rs required. But when it came time for the HOA to uphold its end of the bargain, they were met with silence and inaction. In their words, it is like I bought a home, but I don't even control the air inside of it anymore. The management company doubled down on its position. In one email they wrote, "Without an explicit no-smoking policy adopted in the CC&Rs, the association is limited in what enforcement can be pursued. We can only encourage voluntary cooperation." That line, voluntary cooperation, became a bitter point of contention. To the homeowner, it sounded like a shrug. To the board, it sounded like cover. And to the smoker, it meant business as usual. At this point, the homeowner shifted tactics. They began citing California case law in their correspondence, reminding the board that precedent existed. The Chauncey versus Bella Palermo case was their strongest weapon. A jury had sided with a family who endured the same thing, holding their HOA liable for failing to address smoke infiltration. The damages had been significant. The homeowner didn't mince words. In one letter they wrote, "If this association continues to refuse enforcement, you are not only allowing my neighbor to cause harm, you are creating direct liability for yourselves. I will have no choice but to pursue legal remedies." This was no longer a plea for help. It was a warning shot. Inside the board meetings, tension grew. Minutes later revealed debates that split the directors down the middle. Some argued the nuisance clause clearly applied. The smoke was invading another unit, interfering with quiet enjoyment, and causing documented harm. Others worried about overstepping. They asked, "What happens if we find the smoker and they sue us? Are we opening the association to even bigger losses?" Caught in the middle was the property manager, who kept advising against enforcement without a formal policy change. Their fear wasn't unfounded. HOA boards have been sued before by owners who claimed unfair or selective enforcement. And since the smoker technically hadn't broken any explicit smoking rule, the manager believed the safest course was to do nothing. But doing nothing wasn't safe either. As weeks stretched into months, the homeowner's frustration turned into desperation. They began sharing their experience online, posting to Reddit's RHOA community for advice. The responses poured in. Some commenters empathized immediately. "This happened to me. My HOA ignored it too, until I threatened legal action." Others suggested more drastic measures, installing cameras, hiring an attorney, even contacting local media. One comment stood out. A former HOA board member wrote, "The moment you documented health issues and tied them to the smoke, the board had a duty to act under the nuisance clause. Their failure is negligence. If you sue, you'll win." The Reddit community gave the homeowner something their HOA hadn't: validation. It confirmed they weren't overreacting. It confirmed the board's hesitation wasn't just frustrating, it was legally dangerous. That validation pushed the homeowner further. They drafted a demand letter, professional, formal, and backed by references to state law. They notified the HOA that unless the issue was resolved, they would pursue mediation and litigation. This letter was a turning point. Unlike the dozens of earlier complaints, this one couldn't be brushed aside. It forced the HOA to confront the looming reality, ignore the problem, and face a lawsuit that could cost far more than simply enforcing the nuisance clause. Behind the scenes, the board scrambled. They called emergency meetings. They sought legal advice. The association's attorney reminded them that courts in California had already established liability in similar cases. The safest move, the lawyer explained, was to address the nuisance proactively, whether or not a smoking ban was on the books. But even armed with legal counsel, the board hesitated. They feared backlash from the smoker, who threatened to countersue if penalized. The situation had become a stalemate. One homeowner demanding protection, another homeowner refusing to change, and a board too divided to act decisively. This deadlock only fueled the homeowner's resolve. They began collecting affidavits from visitors who noticed the smoke when entering the unit. They gathered medical notes linking respiratory issues to the exposure. Every piece of evidence strengthened their position, and every delay from the board looked worse in comparison. By now, the story had moved far beyond personal frustration. It had become a battle of principle. The homeowners saw themselves as standing up not just for their own health, but for the rights of anyone who might one day find themselves trapped in a similar situation. As one Reddit commenter summarized, "This isn't just about smoking. It's about whether your HOA protects homeowners or hides behind the fine print." The conflict had reached its peak. A homeowner armed with evidence, a board paralyzed by fear, and an HOA attorney warning that the cost of inaction could be catastrophic. Every letter, every ignored complaint, every moment of hesitation had built to this. The stage was set for the ultimate showdown: lawsuit versus liability. What makes this story so unsettling is that it isn't rare. This isn't an isolated California conflict between one homeowner, one smoker, and one indecisive board. It's part of a much larger, nationwide pattern of HOA abuse and neglect, one that touches millions of homeowners across the United States. Across the country, HOAs are supposed to exist for stability. They're advertised as protectors of property values, guardians of community standards, and mediators of disputes. But in practice, far too often, they become bureaucratic machines, slow to act, quick to punish, and inconsistent in enforcing their own rules. Take smoking disputes, for example. California isn't the only state where homeowners have fought this battle. In Florida, a condo owner sued their association after years of secondhand smoke seeping into their unit. Just like in our story, the HOA claimed they had no explicit ban. A judge disagreed, citing the nuisance doctrine, and forced the board to intervene. The case dragged on for years, costing the association tens of thousands of dollars in legal fees paid out of residents' pockets. In New York, another case involved marijuana smoke drifting through walls after recreational use became legal. Homeowners argued that legality didn't erase the nuisance factor. Once again, the HOA stalled, claiming uncertainty. Once again, residents suffered while the board hesitated. And beyond smoking, the same pattern appears in countless other disputes. Noise complaints, parking fights, landscaping rules, pet restrictions. At their core, these conflicts are about the same thing. One neighbor's actions directly harming another's quality of life, and an HOA either refusing or failing to enforce its own standards. Consider the infamous case out of Texas, where an HOA fined a family thousands of dollars for building a wheelchair ramp without proper approval. Even though the ramp was necessary for a disabled child, the board insisted the family follow the approval process to the letter. Public outrage eventually forced the HOA to back down, but not before the family endured months of stress and humiliation. Or the case in Arizona, where an HOA shut off a community's water supply over unpaid assessments. Entire families went days without running water, only to discover later that the HOA had acted outside its authority. Lawsuits followed. Trust shattered. The damage to the community was permanent. When you zoom out, the numbers tell a troubling story. According to the Community Associations Institute, more than 75 million Americans live under HOAs or condo associations. That's roughly 1 in 5 people in the US. And while many of these communities function smoothly, research shows that disputes are not the exception. They are the rule. A 2022 survey found that nearly half of homeowners in HOA-managed communities had experienced at least one conflict with their board. The top complaints? Selective enforcement, unreasonable fines, and lack of transparency. In other words, exactly the same patterns we see in this smoke infiltration case. Selective enforcement is particularly damaging. HOAs love to tout their rules when it comes to small issues. Trash cans left out a day too long, lawns a little too brown, fences painted an unapproved color. But when the harm is serious, like drifting smoke, unsafe structures, or harassment, boards suddenly go silent. They hide behind technicalities, claim their hands are tied, or insist it's a neighbor-to-neighbor dispute. That double standard erodes trust faster than anything else. It sends a clear message. We'll fine you for weeds in your yard, but we won't protect your health inside your home. Another part of this wider pattern is the power imbalance. HOAs hold tremendous authority, control over fines, liens, and in extreme cases, foreclosure. Homeowners, on the other hand, are left to fight uphill battles just to be heard. The only real weapon they have is litigation, and lawsuits are expensive. Many families simply can't afford them, which means they're forced to live with injustice rather than risk financial ruin. And when homeowners do sue, the deck is often stacked against them. HOA boards use community funds to pay for attorneys. That means homeowners are, in a sense, funding both sides of the fight. Their own legal fees, plus their share of the HOA's defense costs. It's a deeply unfair system, and it deters many from pursuing justice. The ripple effects go even further. Studies show that when HOAs mishandle conflicts, property values drop. Word spreads quickly. Buyers hesitate to move into problem communities, and lenders become cautious. What begins as one board's failure to act can damage an entire neighborhood's reputation for years. The smoke dispute at the heart of this video is just one thread in a much larger fabric of HOA dysfunction. It illustrates how small-scale conflicts, something as ordinary as a cigarette, can escalate into life-changing battles when boards fail to step up. And perhaps the most frustrating part? These problems are predictable. They follow the same script over and over again. A homeowner raises a legitimate concern. The HOA responds with hesitation or dismissal. The conflict festers, creating hostility. The homeowner threatens legal action. The board panics, spends community funds on attorneys, and drags everyone through a costly fight that could have been avoided with early intervention. It's not just about bad actors on boards either. Sometimes it's incompetence. Sometimes it's fear. Sometimes it's simply a lack of training. Most board members are volunteers, not legal experts. They're thrown into positions of authority without the skills or knowledge to navigate complex disputes. And when management companies step in, their advice is often more about minimizing liability than solving problems. But here's the irony. By refusing to act, HOAs usually create more liability, not less. Just like in our California case, the longer a board ignores a legitimate complaint, the stronger the homeowner's legal position becomes. Judges and juries see the paper trail. They see the medical documentation. They see the ignored pleas. And they ask the same question: why didn't the HOA act sooner? So when we step back and look at the broader picture, this isn't just one homeowner's nightmare. It's a snapshot of a systemic problem. HOAs across the US prioritizing technicalities, protecting themselves, and leaving homeowners to fend for themselves. For every story that makes it to Reddit, to the news, or into a courtroom, there are dozens more that stay hidden. Families quietly suffering. Residents paying fines they shouldn't owe. Homeowners giving up and moving out rather than face years of exhausting conflict. That's the wider pattern. That's the real nightmare. And it brings us back to the central question. What are HOAs for, if not to protect the people who live under their authority? At the heart of this case lies a critical question. What are the legal and ethical duties of a homeowners association when one resident's behavior directly harms another's ability to live safely in their own home? From a legal standpoint, HOAs operate under a framework built on three pillars: the governing documents of the community, state statutes, and established case law. Each layer matters. And in California, those layers combine in ways that made this smoke infiltration dispute especially dangerous for the association. First, the governing documents. Nearly all CC&Rs contain what's known as a nuisance clause. The language varies, but the spirit is the same. No homeowner may use their property in a way that interferes with another resident's quiet enjoyment. On paper, this clause is broad enough to cover situations like loud music, aggressive pets, or yes, drifting cigarette smoke. The challenge lies in enforcement. Boards often hesitate to act unless a violation is clear-cut, something measurable, objective, and easily proven. Smoke doesn't fit neatly into that category. It's subjective. It drifts. It varies in intensity. And that gray area is where boards retreat into inaction. But case law has already spoken. California courts and courts in other states have made it clear that smoke infiltration can indeed qualify as a nuisance. The most famous case, Chauncey versus Bella Palermo, set a precedent that boards cannot simply hide behind technicalities. In that case, a family endured years of secondhand smoke entering their home. The HOA refused to intervene, claiming no smoking ban existed. A jury disagreed, finding the board liable for breaching its duty to protect residents. Damages were awarded, and the message was unmistakable. Nuisance clauses are not optional. They carry weight. Beyond precedent, there's also California's Davis-Sterling Act, the body of law that governs common interest developments. It requires boards to act in good faith and to exercise reasonable diligence in carrying out their duties. Ignoring repeated complaints backed by medical evidence doesn't look like diligence. It looks like negligence. Other states follow similar patterns. In Florida, the Condominium Act imposes a duty on boards to enforce restrictions uniformly and fairly. In Texas, courts have repeatedly emphasized that HOA boards are fiduciaries. They owe a duty of loyalty and care to all residents, not just the majority. That means when one homeowner suffers because of another's behavior, the board can't simply throw up its hands and say, "Not our problem." So from a legal perspective, the homeowner in our California case had a strong foundation. They had governing documents that prohibited nuisances. They had state law requiring reasonable diligence. They had case law reinforcing that smoke counts as a nuisance. The HOA's refusal to act wasn't just frustrating. It was a liability waiting to explode. But let's shift from the legal to the ethical. Because HOAs aren't just about documents and statutes. They're about people, neighbors, communities. Ethically, the question is simple. Should a governing body whose purpose is to maintain a safe and livable environment ignore a resident's health crisis because it fears backlash from another homeowner? The obvious answer is no. Protecting health and safety should always outweigh convenience or conflict avoidance. And yet, HOAs across the country repeatedly fail this ethical test. They'll chase down minor violations, paint shades, mailbox heights, grass length, while shrugging off serious threats to quality of life. Why? Because the small stuff is easy. It's black and white. The serious stuff requires courage, judgment, and sometimes confrontation. The ethical failure goes deeper still. When a board ignores a homeowner's cries for help, it isn't just neglecting one person. It's sending a message to the entire community. Your well-being is optional, your safety is negotiable, and your trust in this system is misplaced. That erosion of trust has consequences. Residents stop reporting problems. Neighbors stop engaging. Communities fracture. The very purpose of the HOA, to preserve harmony and property values, is undermined from within. There's also the issue of power imbalance. HOAs wield extraordinary authority, from levying fines to placing liens on homes. Homeowners, by contrast, often feel powerless. Their only recourse is costly legal action. That imbalance places a moral burden on boards to exercise their power responsibly. To ignore that burden is not just poor governance, it's unethical. And what about the smoker in this case? Do they have rights? Absolutely. Homeownership includes the right to enjoy your property. But that right ends where it begins to harm others. The ethical principle here is straightforward. Freedom without responsibility is license, not liberty. In a shared community, no one's freedom is absolute. The ethical duty of the board was to balance those rights, to respect the smoker's autonomy while protecting the neighbor's health. That balance could have been achieved through mediation, through modifications, or through adopting a clear, non-smoking policy moving forward. Instead, the board chose paralysis, tipping the scales toward inaction. And here's the final irony. By refusing to act, the HOA put everyone at greater risk. If litigation had moved forward, the costs wouldn't just fall on the board. They'd fall on every homeowner in the form of higher dues, drained reserves, or special assessments. In trying to avoid conflict with one resident, the board endangered the entire community. This is why the legal and ethical implications of cases like this are so significant. They reveal the tension at the core of HOA governance, the push and pull between individual rights and collective responsibilities, between technicalities and human realities, between caution and courage. When an HOA chooses caution over courage, technicalities over people, and silence over responsibility, it fails both legally and ethically. It fails the law, it fails its members, and it fails the very purpose for which it exists. The California homeowner in this case was right to push back. They were right to demand accountability, and they were right to remind their HOA that governing documents and laws are not shields to hide behind. They were responsibilities to be upheld. Because at the end of the day, this isn't just about smoke. It's about fairness. It's about safety. And it's about the moral duty of any community organization to stand up for its people.
To help unpack this case, let us step into the mindset of an expert, someone who understands both the legal obligations and the practical realities of HOA governance. Imagine the perspective of a seasoned HOA attorney. They've handled dozens of nuisance cases, seen how juries respond, and know exactly where boards tend to stumble. Their take on this situation is blunt. The moment a homeowner provided documented complaints of secondhand smoke combined with medical evidence, the board had a duty to act. The nuisance clause in most CC and RS is intentionally broad, and courts interpret it broadly. Ignoring it isn't a safe option, it's negligence. That single word, negligence, is key. In legal terms, it means the board knew or should have known about a harm and failed to take reasonable steps to address it. It doesn't matter that no explicit no smoking rule was written into the CC and RS. The nuisance clause was enough. Precedent confirms it. The attorney would advise the board to enforce, even if it meant a confrontation with the smoker. Now, let's add the perspective of a community governance consultant, someone who trains HOA boards across the country. Their focus is less on the law and more on board dynamics. Their analysis of this case would sound like this. This is a textbook example of decision paralysis. The board felt trapped between to risk alienating the smoker or getting sued by the complainant. Instead of choosing, they froze. But in HOA governance, inaction is itself a decision, and often the most dangerous one. That insight explains why so many associations fall into similar traps. Volunteers serving on boards are rarely trained in conflict resolution. They rely heavily on management companies, which often give risk-averse advice. Don't act unless you're certain. The result: boards wait, homeowners suffer, and legal exposure grows. Both the attorney and the consultant would agree on one critical point. The board had more tools than it realized. They could have invoked the nuisance clause directly. They could have initiated mediation between the two neighbors. They could have passed a rule restricting smoking in shared wall units moving forward, with proper notice to owners. Any of these actions would have shown good faith effort. Instead, they did nothing, exactly what courts view most harshly. Another important angle comes from a health perspective. Public health experts have long warned that secondhand smoke is not just a nuisance, it's a hazard. The Centers for Disease Control and Prevention states clearly that there is no safe level of exposure. That fact alone strengthens the homeowner's position. A court would look at it not merely as a comfort issue, but as a health and safety matter, which raises the stakes dramatically. And here's where an HOA risk manager might weigh in. Their role is to minimize liability for associations. From their standpoint, the board's hesitation was short-sighted. Litigation is always more expensive than early intervention. By ignoring the complaints, the board didn't avoid liability, they multiplied it. Even if the smoker had threatened a countersuit, that cost would pale in comparison to a negligence case backed by medical evidence. This financial framing is critical for homeowners watching this story unfold. Every dollar spent defending a lawsuit comes from somewhere: reserve funds, operating budgets, or directly from homeowners' pockets. What feels like board politics quickly becomes a community-wide financial crisis. There's also the ethical expert view, often overlooked in HOA debates. Ethicists and community advocates would call this a failure of duty of care. When someone reports harm in a shared community, leaders have an obligation to investigate and act. Doing nothing in neutrality, it's siding with the status quo, which in this case meant siding with the smoker at the expense of the complainant's health. So, what lessons would experts draw from this case? Document everything. The homeowner did the right thing by creating a paper trail. Without it, their case would have been far weaker. Documentation transforms complaints into evidence. Invoke nuisance clauses. Boards often underestimate how powerful this language is. It is intentionally broad for a reason, to cover situations that aren't spelled out in detail. Seek mediation early. An impartial mediator could have helped both neighbors find common ground before the situation escalated. Even if it didn't solve everything, it would have shown the HOA was making good faith efforts. Adopt clear policies. Many associations are now passing explicit non-smoking rules for shared wall units. These rules survive legal challenges because they're tied to health and safety. Understand fiduciary duty. Board members aren't just volunteers, they are fiduciaries. That means they have a legal and ethical obligation to act in the best interest of all homeowners, even when it's uncomfortable. Experts would also stress that this case is a warning for every HOA. Boards cannot afford to treat complaints selectively. If they enforce grass height rules, they must also enforce nuisance protections. Selective enforcement undermines credibility and opens the door to claims of discrimination or negligence. And perhaps the most sobering expert takeaway: when HOAs fail to protect their residents, they create the very lawsuits they fear. They don't avoid liability, they invite it. So, whether you hear it from an attorney, a governance trainer, a health advocate, or a risk manager, the consensus is the same. This HOA should have acted, not only because the law demanded it, but because ethics demanded it, and because basic community trust demanded it.
When you step back and look at the full picture, this story is about far more than just one homeowner and one stubborn smoker. It's about what happens when a system designed to protect communities forgets its purpose. Think about it. This homeowner did everything right. They followed the rules, they documented the problem, they provided medical evidence, and they reached out for help. They weren't asking for special treatment. They weren't demanding luxury. They were simply asking to breathe safely inside their own home. That's the most basic expectation anyone should have. And yet, the very body that should have protected them, the HOA board, turned its back. Whether out of fear, laziness, or misplaced loyalty, they chose silence. And that silence wasn't neutral. It was loud. It said, "Your health doesn't matter as much as our comfort." This is what makes HOA injustice stories so powerful and so frustrating. They reveal how quickly authority can become a shield for inaction. Boards claim they're acting in the best interest of the community, but too often that phrase becomes an excuse for doing nothing when action is hard. The irony here is almost painful. HOAs are famous for cracking down on the smallest things. Weeds 2 inches too high, a car parked at the wrong angle, a garden gnome deemed unsightly. But when faced with an actual health hazard, a proven, documented, harmful nuisance, they froze. They refused to enforce their own covenants. That double standard is what drives homeowners across the country absolutely insane. And here's the bigger lesson. HOAs don't just hold power over property, they hold power over trust. When they enforce selectively, when they ignore real harm but nitpick cosmetic details, they shred the credibility that makes communities function. Without trust, an HOA isn't a steward, it's a liability. For this homeowner, the fight may have ended with lawyers, letters, or even a lawsuit. But for countless others, the fight never gets that far. They move, they give up, they swallow the injustice because they don't have the time, money, or energy to battle their HOA in court. And every time that happens, it reinforces a dangerous precedent, that boards can ignore their duties and get away with it. But here's the truth that needs to be said out loud. Homeowners are not powerless. The nuisance clause exists for a reason. Courts have repeatedly recognized its broad authority. And when paired with documentation and persistence, homeowners can and do win. The takeaway for viewers is this. If you ever find yourself in a similar position, don't let silence discourage you. Document everything. Learn your rights. Demand accountability. HOAs count on apathy and exhaustion. The strongest weapon you have is persistence, backed by evidence. And for board members who may be watching, let this story be a cautionary tale. Your role is not to make everyone like you. Your role is to enforce fairly, act ethically, and remember that your fiduciary duty is to every homeowner, not just the ones who cause the least trouble. Doing nothing is never safe. It is never neutral. It is negligence. And negligence has consequences. At the end of the day, this isn't just about secondhand smoke. It's about the larger principle. Do HOAs exist to protect communities or to protect themselves? Every case like this pushes that question closer to the center of public debate. And as more homeowners share their stories, as more lawsuits set precedent, the pressure on HOAs to change will only grow. So, let me leave you with this thought. If a board can fine you for your mailbox color, but won't lift a finger when your health is at risk, what does that say about their priorities? And what does it say about the system we've built around HOAs in America? I want to hear your thoughts. Have you faced something similar? Has your HOA ever ignored a serious problem while obsessing over petty details? Share your story in the comments. These conversations matter, not just for venting, but for building awareness, for sparking reform, and for reminding homeowners everywhere that they're not alone. If this story resonated with you, hit that like button. It helps more people find these videos and join the conversation. Subscribe if you want to hear more HOA injustice stories, real-life cases, and expert analysis. And share this video with someone who's fighting their own HOA battle. Sometimes knowing you're not alone is the first step to fighting back. Because at the end of the day, this isn't just a story about one homeowner. It's about all of us. And the question we have to keep asking, when power sits in the hands of a board, will it be used to protect or ignored until it hurts?